Good morning, ladies, and welcome to a hearing into an appeal under the Community Power Empowerment Scotland Act 2015 in relation to the former co-op in Castlebay in the Isle of Barra. My name is Paul Coquette, and I'm a reporter appointed by Scottish ministers to report on the appeal that's been taken by the appellants in this case in relation to their application to seek a transfer of the property of the former co-op to them. As I say, my role in relation to this matter is to report to ministers on the merits of the appeal and the objections to the conditions as originally were imposed in the decision letter of 16th February of this year. We're proceeding under the Community Empowerment Scotland Act 2015 and also under the Asset Transfer Request Appeals Regulations of 2016, although we may touch in the course of this hearing with the review procedure regulations as well. I'm grateful to parties for indicating on Friday that steps were close to being reached between the parties as to an agreed set of conditions that they regard as appropriate for imposition by ministers in the context of this appeal, and equally grateful for the effective shortening discussion in certain respects as we'll go through this morning's hearing. I should say, perhaps by way of general introduction in relation to the conditions, is that it appeared to me, despite the indications there, which were very helpful to me, it felt useful for me, having arranged this call and this hearing, to continue with it. Part through no fault of anybody's, I've only obviously had a limited amount of time to have looked at and considered the conditions as agreed between the parties. And thirdly, slightly more technically, I remain appointed to report to ministers until my appointment is revoked. And it may well be ministers at some point may well revoke my appointment if they're satisfied that the appeal can be withdrawn. I'm not sure the appeal can be withdrawn without the agreement of ministers, unless the appellants go back to the original conditions, and that clearly is not what's intended. But as far as I'm aware, no request had been made as yet for the appeal to be revoked, and therefore I require to continue my work, obviously informed by the situation in relation to the conditions, but on that basis. So I thought it was the most efficient use of time, rather than postponing today, to allow parties to decide, allow the appellants in particular to decide what they wanted to do and whether they could simply withdraw their appeal. I felt it was beneficial to proceed with this morning's hearing. The hearing format, I think, was vindicated to you before, is an informal procedure. It's not a full public inquiry, and that's one of the advantages of doing things virtually. And that is that the formal position is that it's a discussion of the agenda that's been circulated before that goes through me as chairing the meeting, but it's not a full public inquiry in the sense that there are no formal witnesses being led, there's no cross-examination, there's no re-examination and the like. So it's relatively informal, and strictly, as I say, questions would go through me as the chair of the meeting. But in fact, I prefer to run these things rather more informally. I will give parties the opportunity to comment on various items as they go. But I don't apply too strictly the rule about questions going through me. So if anybody has any questions, please just say. I will endeavour to make the proceedings this morning as informal as possible. I should also say, for those who are unfamiliar with DPA's practices and hearings, please say if anything that's happening in the course of this hearing is unclear, or you have any questions or anything you think is unfair that's happening, that you're not getting a say, just shout. So please feel free to say, because I realise that for some participants this is maybe not a familiar procedure to go through, and as I say, I want to make it as completely relaxed as possible. I've not had any intimation of any special needs anybody has that need to be accommodated within the hearing this morning, but if there are, obviously we'll try to endeavour to do that as much as we can. The hearing this morning is being webcast and is available. Obviously, the only participants are those that are on the call just now, but it's available for people to view live, but it also will be on the DPA website at a later date for people to look and view. And so if anybody here wants to refresh their memories to what's been said or done on the hearing, they'll be able to do that. And that, indeed, along with all documents that relate to this particular appeal, can be found by going to the DPA website and searching under the case reference, which is CAT-410-2. And we proceed this morning on the basis that all participants are consenting to the use of their images and the use of materials for the purpose of our website for data protection purposes. The hearing, when it was originally set, is set for a full day. I think that it's possibly unlikely that we'll need anything like the full day today, but we'll see how discussion goes. But in the event that we do need a reasonable amount of time, my intention would be to break at around 1 o'clock for about an hour if we need to go into the afternoon. But also, I'm conscious of the fact that virtual hearings are a different sort of proceeding from face-to-face meetings, and I'm very keen to take breaks in the proceedings to give ourselves a chance to take a comfort stop for 5 or 10 minutes. If anybody wants a break any other time for any other reason, just say, and we'll accommodate that as we go. For the purpose of this morning's hearing, on the basis that all parties are familiar with all the witness statements and all the materials that have been lodged, there'll be no need to lead evidence in that sense of going through the position of various witnesses, but we'll just go through the agenda and deal with the issues as they arise and as they go. As I say, the agenda is as circulated, although with various amendments. Before I go on to that and say one or two other more preliminary things, I'll maybe just invite parties to introduce themselves and witnesses or other attendees at today's meeting for the purposes of the record, and starting with the council.
Good morning. My name is Alan MacDonald. Apologies, I'm hearing a bit of an echo. Is that?
I'm hearing
others hearing that? Oh, you are?
Are others hearing an echo? I can go on to mute just now and see if that helps.
Thank you. Yeah, that does help. Thank you very much. Yes, it's my name is Alan MacDonald. I'm in the legal services in the Corley, and I was a legal advisor to the appeals panel, which sat to consider the initial review from Barra. And I'm accompanied today by Councillor Ian MacLeod, and Councillor MacLeod was one member of that panel and is representing the panel today. So between us, and largely, I would imagine, I've said to Councillor MacLeod that I will try to answer the questions the best I can, and therefore, hopefully, there won't be too many questions falling on Councillor MacLeod. But if essentially we'll work it together, and hopefully we'll be able to assist you in that regard.
Okay, thanks very much. And the appellants?
Hi, I'm Skinner. I'm founder and manager of Barra here in Castlebay, Isle of Barra. Over himself.
Hi everyone, I'm Chris Murphy. I am a solicitor at McRoberts LLP, and we are acting as agent for Barra.
Thank you. Thank you. The agenda this morning, as is as circulated, I'm slightly anticipating that the certain aspects of the agenda may not require to be gone through quite to the extent that we might have anticipated originally, and it may be, for example, that there's less time we need to spend on looking at the previous CAT decisions made by the council and their significance for the current appeal. And equally, I'm not anticipating spending a huge amount of time looking at the reasons why the renovation work have run into some concerns that they might not have been possible to be done quite as quickly as otherwise anticipated because of Brexit and COVID implications. It may be we need to spend a bit less time on my question as to why the council were seeking all of the conditions. We'll break those down later on. And generally, I'm not anticipating that we'll need to spend an awful lot of time looking at the report that I wrote in relation to Brechin Infirmary, which I think has been circulated. I should say that was a much more complex set of circumstances. For those of you who've taken the time to plough through, that was a much bigger venture in terms of the size and scale. I think there are some relevances to that, but we may not need to be going through quite all of those quite to that extent. But subject to that, I was intending really just to work through the agenda as it's been circulated. But I don't know if parties have any comments or further suggestions of how we deal with the agenda for the purposes of today. And again, starting with Alan.
Thank you. That sounds fair to me. I think I'm happy to leave it with yourself. In respect of previous CAT decisions, happened to put something this morning that I might mention. It might be new information, but it's not to influence anything. It's to comfort Barra, essentially that I think they felt that maybe some of the conditions here were harder on them than they have been on others. And I just thought I would mention something about one of the other transactions, which I thought I would refer, but not necessarily to be part of the decision, but just as comfort. So I'll if that's not relevant, that's fair enough. But I just thought to mention that at this point.
Well, that's very helpful, and feel free to bring that in at the appropriate time. And Chris.
Yes, I think that's fair. We're happy to run through the agenda. And I'll take Sarah nodding to be in agreement with that.
That's all fine. Okay, many thanks for that. I should just repeat what I said in correspondence previously, although this may not actually materialise as it turns out. At the end of the day, and this will be of comfort to the lawyers on the call, I'm not expecting the lawyers to be instantly responding at the end of the day with a set of closing submissions. The extent to which closing submissions are needed will remain to be seen. But the practice I tend to adopt is to give people 7 days from the hearing to make a closing submission if they think fit. When I looked at this initially, I was going to encourage you to do so, but actually it may well be that there's less need to make closing submissions. But so you can be comforted at the start of the hearing that I'll not be turning to you at the end of today's proceedings, at least expecting you to have a coherent and drawn together set of closing submissions. The 7 days will be to close on next Tuesday. So next Tuesday will be included within the 7 days. So 7 days complete in terms of that. I would remind you, although you hardly need to be reminded, that any closing submissions that are made and are felt to be appropriate shall contain no new evidence. They're a summary of the case and nothing new can be introduced, except perhaps if the need for that arises because of something that comes up in the course of today. And the second thing I would say is if I could ask you simply to send the closing submissions to our case officer within DPA and not copy them to each other. That's not our usual practice. We always tell people to copy papers to each other, but in this case I'm saying don't do that so that no party has sight of the other side's closing submissions until the 7 days are up. We will do the circulation of that once that process is completed. So hopefully that's clear in relation to closing submissions. And just two last points before we get on to the agenda. One of which is it's come to my attention that the originally circulated report in relation to the Brechin Infirmary didn't have a connection with the hyperlinks that were embedded in that report. I don't think any of the hyperlinks that were there are relevant to the issues that we need to discuss today, and that's now been corrected. So if you need to look at the hyperlinks in relation to that, that's now on the case management system. If you do want to refer to hyperlinks or any representations today that relate to that, and you've not had a chance to do that, then please say, and we'll find a way to accommodate that. But I'm rather hoping that technical glitch with hyperlinking will not cause any prejudice to any parties. And the last point I was going to say is our case officer normally in communication with you is Jane Robertson. She's actually on a couple of weeks leave, starting with this week. So the email communication came from Emma Brown yesterday, and so please could you note for the next fortnight that all communication should go both to Emma and to Jane, and that's a DPA, and that's thereby the way in which I'll be able to see things. It's obviously important for closing submissions that they go to the right people. So if you add Emma as well as Jane Robertson to the copy recipient list. Okay, with those preliminary matters dealt with, the first issue, which I just really welcome thoughts on from the parties, was item 1, and this is the question which I'll need to address, even if I set out a fuller report. It's just the views as to whether the appeal on the 17th of March was made in time in terms of the asset transfer appeals regulations. I'm going to invite parties to say what they want in relation to that, but I should say I've obviously seen the decision letter of 16th February. I've seen the appellant's lawyer's letter of the 9th of March, and I've seen the appeal itself dated the 17th of March, and I've noted in particular the letter of 16th February from the council indicating that the 20 days expired on the 17th of March, which by my calculation was probably not the right date. I'm happy to go over calendars of people, but my calculation is that the 20 working days was the 15th of March. If I'm wrong about that, please let me know. But I just to alert you to the fact I have those issues. I've got one specific question, but I'll first of all open. I won't necessarily always open to the council first of all, but I'll maybe open to the council first of all. If you could indicate what your views are on item 1 of the agenda.
Thank you. Thank you. It was just when I think I may have highlighted this matter just in case it were to cause a problem further down the line. So I think in the determination, the coroner set the date based on the regulations, appeal regs, and had set the date of, I think, 16th March. They may have given leeway of a day, and the appeal was submitted on the 17th of March. So in respect of the coroner's position, and as said, I think in either an email or covering email to my response, one or the other, in the coroner, we made it clear that it wasn't a concern and it was of no prejudice to the coroner whatsoever because Barra's representatives had actually given the coroner notice of exactly the terms of the appeal. So there was no prejudice, there was no concern. It was just highlighted lest it were to cause problems down the line and it might be something you wanted to deal with. So if the coroner is able to say expressly that they're happy for that to be deemed as something which may have been an error, but as it has caused no prejudice, we're happy to essentially put that to one side and not allow that to impact upon the appeal in any way. I think that would be the coroner's position.
Okay, thank you. And for the appellants?
Yeah, I think very much reflective of what Alan was saying. The appellant took the date that was set out in the decision notice, which said by 17th of March as being correct. And we then got in touch with the authority to attempt to negotiate at an early stage. We appreciate that because of panel reviews, that is quite time restrictive and there wasn't maybe enough time to get that done at that early stage. But then we received the cover email from Alan again, which basically reflected what he said there in terms of not prejudicing the authority. So we're happy to proceed on that basis.
Going on off mute there as always I've answered. That's fine. I only had one factual question in relation to the circumstance. As I mentioned a moment ago, I'd noted the letter of 9th of March on behalf of the appellants. Now, on my reading through that attached as an annex the anticipated grounds of appeal that were going to be taken in relation to this matter. From my reading, Paris, I think reasonably closely, I could see no difference between what was intimated on the 9th of March and the appeal grounds that were eventually taken on the 17th of March. And now, if I'm wrong about that, and I don't even necessarily need an answer right now because it might require a kind of detailed comparison of the two, if that's not been done. But I'm proceeding on the basis that there's actually no differences, and certainly no differences of substance between the grounds intimated as being likely to be taken and the grounds actually taken. But if parties can tell me I'm wrong about that I'll need to know that, because that's obviously quite important. But I could just say to parties, I could see no difference between the two. So again, if anybody wants to comment on that at this stage, or as I say, within the days ahead.
Well, I think you're correct. The intention was to be as open as possible with the authority, and to let them know that that's exactly what we were looking to appeal on, and that the purpose of the appeal was to preserve the appellant's position.
Okay, thank you. I take it the council don't have anything to add in that respect.
No, that was certainly my understanding, and that it was exactly the same, and therefore, you know that the council had notice of the terms.
Sure.
A significant period before the deadline.
Okay, thank you. Item 2 of the agenda was I suppose a technical issue, and I hope I made it clear what I was driving at in sending out the specified notice at the beginning of July. And again, my purpose here is just to seek views on the issue arising, including telling me if it's not an issue. I very much accept that there's no desire or intention for circularity. The issue that was in my mind was effectively a matter of statutory interpretation, looking at the 2015 Act, and that is the question as to whether the right to take an appeal against a decision of a local authority that requires a review first is satisfied by the first review, or when the decision on review was gave rise to a different outcome. In other words, the refusal was turned into a grant subject to conditions. Whether the correct interpretation of the legislation is that in turn needs to be reviewed again. Now that would mean 2 reviews in relation to the same case, but it would be reviews of different things. One of which is a review of a refusal, and the other is a review of the conditions. So I hope that my previous expression of what the issue in my mind is, and if it wasn't clear, hopefully what I've just said is clear. So I welcome again the council, first of all. What's their view? And I quoted the section before, which is 86(1)(b)(2), which was the ability of an appellate body to seek a review of conditions, and that's expressly about conditions. But in section 88(1), the ability of the appellants to appeal is dependent on a review having taken place. And my question, I guess, is whether the appeal can validly be taken based on the review of the refusal, or whether there needs to be a second review because there's a review of conditions. So again, starting with the council.
Council position, in short, is that it did not anticipate any further review, and the process which has been followed is our interpretation of the statute. It's a short point, but that's where we are. If you have any further questions, please let me know.
I mean, the question with my point of view is how you interpret the statute. I looked at the statute, I looked at the review regulations, and I looked at the guidance that's available to community bodies. None of them really shed an awful lot of light on this particular issue, and none of them said expressly whether a second review was necessary or not. The review guidance might be interpreted as pointing to the need for a second review, because it does suggest that there should be an internal review of conditions. And of course, there hasn't been an internal review of conditions by the council. And so that it was that really triggered it in my mind. And it's a genuinely open question as to whether there has been a review of the council decision, but it was a review of the decision to refuse completely. It wasn't a review of a decision in relation to the conditions. So that, I mean, if you've nothing further to add, then I can accommodate that. I'll come to the balance just in a second. But it was just that particular issue. And as I say, that's recognising that clearly there's to be no endless circularity of all of this. It doesn't go on forever. That you must continue having reviews. That makes no sense. But the inference, at least from the guidance, is that every decision of a certain nature is subject to review, and there's been a decision to impose conditions that's not been reviewed. Does the council want to add anything more about whether I should move on to the appellants for their view on that interpretive point? Yes, it looks, Council Alan, you're going to say something. You took a breath in as if you're going to say something.
Thank you. So apologies, I am slightly behind on this one. So the review in that instance, so in this instance, the review has been determined by local members, by a panel, which has set conditions. From your interpretation of the various regulations, who would be undertaking the review of the conditions? And apologies, I shouldn't be asking you these questions, but that would help.
No, it's not my proposition. I'm just testing it. If you look at the two sections that I've quoted, I mean, let's section 86 1B2. Let's say that what that says is, if the original decision by the council had been to grant subject to conditions, and those conditions were not acceptable to the community body, they could have sought a review of the conditions. And then if they didn't like the outcome of that, that gives them the right to appeal to ministers. As it turns out in this particular case, what happened was there was a refusal, as I understand it, and then the appellants asked for a review. And the decision on review was that the application should be granted, but subject to conditions. And so in that scenario, given that section 86 1B2 gives an appeal, or gives a right for a review by the same authority in relation to conditions, my question is, there hasn't been one. Now, I've said that means there would be two reviews, but one is a review into the principle of the granting, which was successful from the appellant's point of view because they got their grant. But the second point is in relation to conditions alone, which is qualitatively different from that. The legislation provides there should be a review by the local authority. If asked by the appellants, appellants don't have to ask, but if they ask for a review of conditions, you're obliged to do it. Problem is when you get to section 88 that in local authority transfers, the appellant cannot appeal to ministers unless they've gone through the review process.
I see. In that instance, I think it's a matter that affects the appellant in terms of the interpreter of the statute, and I suspect they will have something more intelligible to say on it than I will. But just in terms of the how it works in terms of the Corley and how this matter was reviewed, the initial decision, there was an evaluation undertaken by officers and decision taken by officers. So the review was undertaken by the appeals panel. So given the appeals panel has taken this new decision and set new conditions or set conditions, there might be a practical problem there as to who in the local authority would undertake the review of those conditions. So that would be my only comment. It might cause practical problems, but I have nothing else to say on the actual statute, and I suspect Mr. Murphy will have something better to say on those.
That's very helpful, but that I can see that's a real practical issue. That if this were a matter of concern, hopefully it's a rare situation to arise, would lead. I can see would lead to administrative complications from the council. But I'll move on to Chris, because obviously he is the greatest interest in this issue.
Thanks. I think it's maybe not terribly clear in terms of the guidance and legislation, as you mentioned. I think from the appellant's perspective, they put in their initial application, that was then rejected. They then appealed to the authority, who had then granted it based on conditions. And I think there might be perhaps a bit of confusion on the fault of neither side in terms of what a review constitutes from the authority, as the authority decision notice that came out stated following review by the council, which they took the case by the local authority under section 86(2) of the allow them to make their appeal to Scottish ministers under section 88 of the Act. And I think, again, in that decision letter, setting out the right to appeal at the end of that letter, saying if the terms and conditions attached differ to a significant extent from those specified in your request, which they did, as the appellant didn't have any conditions attached to the request, that you may appeal to the Scottish ministers. So that's where the appellant began that proceeding.
Okay, thank you. I can see the force in that. I was looking at, you were speaking there, Chris, at the end part of the council's letter there, which is certainly clear in its terms that it anticipates the next step being straight to the appeal to ministers. But that's obviously entirely consistent with what Alan's just said in the way the council were looking at things. So no, that's very helpful. Okay, well, no, thank you. I will reflect on that. I don't know if anyone wants to say anything further. I'm very happy to reflect and consider what I say in my report about that particular issue, and leave that perhaps to others within Victoria Quay to work out what the intention was, since it was their guidance and their regulations. But I'm grateful for the points you both made, and I understand them. I think I understand them, which is will help. Okay, item 3. I think I mentioned earlier that there was 3 preliminary items, and the third one is the last of the 3 preliminary items in my mind, and that's just confirmation. I always like to try to make sure that if there are any other parties other than those who are looking down at me right now, who have a genuine, legitimate interest under the regulations in this, that we're all completely satisfied that everybody who has an interest and has expressed an interest has had an opportunity to input into this process. From my reading of this, on the original application, I think there was 18 letters of representation, either of support or objection. I have seen also a notice that was issued after this appeal, which asked for anybody to make representations by the 18th, I think on the 8th of April. There does not appear to me to be anybody who made representation in relation to that further notice, and there do not appear to me to be any of the 18 persons who've made representations in relation to the issues concerning this appeal. So I'm therefore proceeding on the basis that there are no other interested parties. But again, if any party to this call feel that that's not the case, now's your chance to say, and we'll work out what we do then. But I'm proceeding on the basis that the parties as I'm looking at them. That looks all fine. It looks so no one's disagreeing with that, which is absolutely fine. Okay, next on the agenda, I was actually going to go straight on, if I can, just to the conditions rather than going through, as I say, the relevance of other cases. We can come into Alan's point about that as we go through. And the first one was condition 3. And this, of course, has been subject, I think, to a suggested minor adjustment to cap the expenses in relation to the outlays concerned. So it doesn't appear to be a matter of great contention. I only had 2 questions, in fact, from parties. I thought it'd be useful for the record if the council were able to indicate just what the sort of the general nature of the outlays that they anticipate being involved in. I can see that they're not asking for, and it's perfectly reasonable approach, that they're not asking for their own internal legal expenses to be met. and that sounds absolutely fine. But it might be quite useful just for me to get a sense, just what are sorts of outlays. I see the cap that's there. What are the sorts of outlays that are involved in this? And my second technical question is: I'm assuming that this transfer, when it goes through, is one that would induce first registration in the land register.
Thank you. I'll address that. And your last point actually is key to this. So, given that was my assumption, oftentimes when the Corla are undertaking conveyancing works, the greatest expense is producing a plan, and to cap that, to have any cap whatsoever on that, particularly up to it can be up to £1,000. So that was a concern, but the title has, since this process started, the title has now been registered, so it is in the land register, and therefore the Corla no longer has concerns about the outlays, and I would expect them to be minimal. They would just be the standard searches, etc. So I mean, the 750. Agreed there. There shouldn't really go near that unless there's something out of the ordinary requested by Barra. But as you say, there will be no legal fees charged. It's just outlays. It's just costs for the Corla. And the concern there was a plan that's no longer a concern. So they needn't even budget for that amount unless they have some sort of out of the ordinary request in terms of I can't exactly think what, but in terms of their conveyancing solicitors might ask for something that's out of the ordinary. But it isn't a concern any longer because the title has been registered since this process started.
Okay, thanks. That's just really useful, and I can see why that would make an important difference in terms of the council's position. And I also recognise, as you do, Alan, that when you go into a conveyancing process, you can never entirely anticipate what might be thrown up. Especially if there's an analysis of a title, old school style. So if someone has to get a defective title indemnity policy of some sort of nature, or things of that sort of nature could in theory arise, and you can never tell before you examine the title if that's arising. So I do accept that there's a degree of uncertainty at the start of the process. But Chris, I don't know if you want to add anything to what Alan said on that particular issue.
No, I don't think there's much to add from the appellant's perspective, unless Sarah has something that she'd like to say. From the appellant's perspective, it was just a case of having an actual physical number attached to that condition, and that is, as you'll have seen from the agreed conditions, that's now been achieved.
Okay, anything else from others? No, that's one thing from the perspective. Okay, thank you. And on condition 4, this was the issue about the use in accordance with the request. And from what I can make out from the amended terms and conditions, and I'll be look to the appellants first of all here, the wording looks unchanged from my perspective. So I'm assuming that the grounds of objection in relation to that are now effectively withdrawn. I mean, there's two issues, one of which we may touch on a little bit later on anyway, and that is in relation to a situation where the appellants change the constitution in such a way where they no longer are limited in their obligations to carry out work within community use. But the other is a situation as to whether this is broadly within the request itself. I mean, the request itself is quite broad in its terms. I'm not completely ruling out the idea that the world will change in the next years and there might be something different to arise that we might take it out with that. But I don't know if, Chris, you want to say anything particular about condition 4. As I say, I'm assuming now any objection you had to condition 4 has now simply been withdrawn. If, as I say, it looks like the terms of that are the same as what they were on the terms imposed by the council.
Yes, I think that's right, and taken together with the other conditions, and I think that's the key point, is that everything's sort of taken together as a bundle and the agreed condition is something that the appellant is happy to propose no amendments to. And I think, as you mentioned, in terms of a constitutional point of limiting scope of changing constitution from affecting this by tying it into the request itself.
Okay, thank you. Right. On that basis, then going on to condition 5. Condition 5 looks pretty similar to what it was before, just with the exception that within the relevant period where a security or clawback might be imposed, there might be a sale to another community-controlled body. Now, again, I'd maybe go to the appellants first of all. It'd be useful, again, Chris, if you just explain and set out your position. As these are agreed terms, I'm assuming that therefore the various objections that were put before and the suggestions of a shorter time period of 3 years and the limit of the obligation to 50%, those are grounds that are no longer being pursued by the appellant.
Yes, that's correct. And I suppose the important thing for the appellant was that they've tried very hard, and it's taken a long time to get to this stage, and they are hopeful that the asset will transfer to them and that it will remain in community body control for as long as possible. And by adding in the proviso that the appellant can sell the property to a community controlled body without activating that clawback, or in the event of no community controlled body being available back to the authority, again without the clawback. I think it's just a case of distancing that, where the only way that clawback would come in to view is within that 10 years if the appellant decides to sell in the open market, and that's never the intention of the appellant. So I think that's fine.
Yeah, no, I can see that. I mean, actually, I had a number of questions on this condition. If the appellants have been insisting on their appeal, and I think all bar one of them, perhaps it become redundant in light of the withdrawal of the grounds in this respect. But I suppose the one that remains valid, or a question I'd just like to pose again to Chris perhaps, really is a follow-up to what you've just said. You've said that the appellants have no intention of selling. There's a number of kind of things where I step back when I'm looking at my recommendations, and I'm going to draw one of them in now and invite parties, starting with Chris, then going to Alan, about the impact of, actually this applies to all conditions, but I'm looking particularly on the standard security one here, is the implications of an insolvency event. Because obviously one legitimate issue, and we all hope that this all works and these scenarios we have to explore don't come to pass, but the indication that there's no desire to sell, and if there is a desire to sell, it will be on the community body, it will not necessarily apply in relation to the scenario where the community body fails, which we hope it doesn't. But if it were to fail and there was an insolvency practitioner going in with perhaps a different approach and an obligation to the creditors to do what they can. So again, I suppose my question is to invite you just to sort of tell me what you think the position would be in relation to this condition, especially in the event of an insolvency event occurring within the 10-year period.
So I think I might actually relay this question to Sarah, if that's all right, just because she will have more of an idea than I do at this stage.
And again, we're hoping this won't happen, but yeah, Sarah.
Yeah, we're quite a strong community company, and we certainly hope that won't happen. And we've got all the checks and balances in place, so that if we were going to get into trouble, we would do the best to stay afloat. Does that answer your question?
Yeah, I mean, I can certainly see that, and I've absolutely no doubt that all best endeavours will occur. I suppose the question relates to if the assumption is being made that this will all work because it's the appellants. And they're obviously going into this completely in good faith, and I entirely, absolutely accept that. But my only question would be, as I say, if that doomsday scenario were to arise, those who might, like a bank or whatever, might end up getting hold of assets and taking a rather more hard-nosed approach to these things. But it may well be, I mean, the position may well be that, I hope we don't have to explore too much of the detail of all of this, is that when I'm looking at the condition, it's talking of a 10-year period. Now, I'm assuming that what happens is if the sale happens within that 10-year period, if a sale were happens within the 10-year period, not the community body, and the purchase price received was more than the 50,000 current value of the property, then taking off the £5,000 and taking off the improvements made, it's the actual value of the sale that's supported by the standard security, not just the 50,000. So that's the sort of the basis of which I'm proceeding. But I'm also proceeding the basis that 10 years down the track, the appellant's position would be is the community benefit they will have brought to the town of Castlebay and to the community of Barra will well exceed the £45,000 discount that they've got, and will exceed the extent to which, even if the property sells for a higher value, once you've had a security as long as 10 years, because I thought that would be what your argument was, is the community of value you are bringing would mean that actually it's not really a sale for a discount once you've been operating for X number of years, and therefore it's not really a discounted sale at all. But yeah, an argument is once you get to 10 years, I'm not putting words in your mouth, but once you get to 10 years, then you'll have brought a community of value that means there's no need for the standard security beyond the 10 years. I mean, is that, again, I'm trying not to put words in your mouth, but is that a fair sort of assessment of how the community body would view this issue?
Yes, we can already put into money terms how much we've brought to the local community since we've been in existence, and that is certainly way over. We've been in existence for nearly 10 years now, and it's certainly way over £45,000.
Yeah, I'd certainly, if you only need to bring that benefit over 10 years, then the community benefit you need to bring is only £4,500 every year, and then after 10 years you'll have brought in 45,000.
Yes, and we exceeded that.
Yeah, although that as I say, that makes a bit of an assumption of what the sale price would be. I think rather than spend time at this meeting, although we may have to, rather than spend time at this meeting trying to calculate what we think the annualized monetized community value is, because that may not be an easy thing to do, I'll maybe turn to the council and just see if you have any observations, Alan, that will be inconsistent with that sort of approach. In other words, the idea, do you accept the idea that 10 years down the track, the discounted price of 45,000, insofar as community benefit can be monetized, will be matched or exceeded by the time the community body have operated for 10 years?
Yes, that sounds fair to me. And it just, at the time when the conditions were set, the appeals panel felt that the 10 years was an appropriate period, and to go beyond that probably would constrain a community body further than the 10 years, might not be fair, notwithstanding that the use restriction still remains. And also, it would be worth noting that certainly in previous iterations of such conditions, the terms purchaser is defined, or term purchaser is used along with the phrase and successors, or is defined as purchaser and successors. And when this transfer takes place, there will be burdens on the title, and so that will constrain any successor who has obtained the asset through insolvency proceedings. So, as you say, so it is relevant, and the security also will assist with that. So, after 10 years, I think the appeals panel's view was that, as you explained, that sounds a very good explanation to me. But even beyond that, it just felt that it was too constraining to be setting a period for longer than 10 years, and 10 years was reasonable, but less than 10 years. I don't think the appeals panel were keen on anything less than 10 years for the clawback, simply because the asset is being sold at a discount, and just to provide a disincentive from Barra, who have said that they wouldn't be doing it anyway, or any future owner from selling in the open market, and the asset going out of community ownership. So yeah, I think exactly what you said sounds appropriate to me. Yeah.
Okay, thank you. And again, I should emphasise the disincentivizing that we have in mind here is not to do with the appellants, because they clearly are committed to making this a success. It's disincentivizing in the hopefully unlikely event anybody else required to be trading or dealing with the asset. But no, that's very helpful, and I think that probably answers really all the points I had in mind in relation to condition 5. It was just testing that issue, but yeah, your explanation, Alan, as to the sense and the balance that the review panel had taken towards the appropriate period does make perfect sense to me. And of course, the appellants are no longer insisting on their argument for a shorter period, so we don't have to spend time looking at whether a period other than 10 years is appropriate. I just the value of the property now may not be the value of the property even regardless of the improvements that may have that's helpful. And they're my questions in relation to condition 5. Condition 6. Actually, looking at this, I mean, it might be useful again, maybe to ask one or other of you to sort of just to give a bit of a kind of an explanation. The other conditions look a lot more different from the ones that were there before. I suspect, but I stand to be very much corrected, that condition 6 is not actually massively different from what it was before. It actually contains a lot more work. And words I'm about to say in relation to, again, the building in the capacity of as a community control body as a kind of an initial step. So any sale that might exist can take place, but the steps that are set out there, you must go through the option, first of all, of looking to a community control body to do the sale, and the conditions and the qualifications to that are designed to make sure that it's all a legitimate exercise and it's all properly evaluated and everything's gone through. So those extra clauses, and again, I presume, unless Chris tells me to the contrary, this has led effectively to the objection to condition 6 being withdrawn. That really is the only difference between the clauses. But I don't know if either of you want to say, I mean, we start with the council first of all. Either of you want to say anything about the kind of the genesis of the various modifications, and there's anything else I should know? I've got a couple of questions about the condition, but before I get into that, just anything about the sort of the basis in which this modified condition was adjusted and agreed by parties.
Thank you, and I'll probably defer to Chris for a good bit of this. But from the Corla's perspective, it was, so this is just, I think it was actually raised elsewhere. It may have been yourself who raised, why are all these protections needed? And the idea was they would work together. In terms of preemptive right, it's generally standard, I think, for Corla sales, but the likelihood of using that preemptive right, I think, is probably probably very, very, very unlikely that the court would actually use that. So really the important thing is here that if there is an attempt to sell by Barra, that it would be a community body who would have the opportunity to take title to the building. But what was important for the Corla when we were back and forth in respect to these conditions was a decision on what community body would be chosen being an asset wouldn't just be down to Barra to make that decision. There would be an evaluation process, and thereafter there would be a degree of just for the community of Barra, just in case there were more than one body looking to take title. It was an independent body referred to there, who would assist in the process, and if they weren't able to be fine. So that's really the common concern, was that that the process would be fair if there were more than.
Before I go to Chris, I should go to him in a second. I was assuming, reading the condition, that the reference to the evaluation of the alternative community controlled body would be in effect to apply the principles of community empowerment and community asset transfers to that successor community body. It doesn't say so, but I'm inferring from that when it references an evaluation, because this is all in the context that this policy context. I would assume that the evaluation there is in that context. But you're nodding there that would be the basis in which you would anticipate the evaluation process done following an advertisement.
That was certainly my understanding. We haven't expressed on that, but given the context, that's exactly how I would see it. It was useful to be less prescriptive on that, so as not to constrain the body too much. But if there was an attempt to move away entirely,
not criticising the drafting. It's always a difficult balance between broad brush to give maximum flexibility, prescriptive, and that part of drafting. So it was a question rather than a criticism. Go over to Chris now. Do you have anything to say of the implications here?
Sure. Thanks, Alan. I think that's pretty like the normal to that. And I think it does, and you can always trust a lawyer to add more wording to the clauses. Was and again linking back to what we said about condition 5, the appellant is really keen for, if in any event that the appellant, that there is a appropriate community body in place who can take over and continue that work. And in terms of the over to another community controlled body, that was, I suppose, a result of the negotiations between ourselves and the authority. We're happy for that to fall between the two, and then in the event that one of the two parties don't agree, then it would fall to that independent side. And I think you're correct in terms of evaluation falling under the legislation, even though it's not prescriptive there. And again, referring back up to condition 5, I think we narrated that community control body comes straight out of the definition from the Act. So I think it would follow that is the intention for that clause.
Okay, right. Thank you for that. I two, I think, specific questions in relation to that. The first of which is I note that there's still the fallback at the end of the day gives the council the right of preemption. Now, Alan, I think you said that that's a relatively standard term and concept of the right of preemption. I know there was reforms to rights of preemption back in the Title Condition Scotland Act 2003 that modified the ability. It made modifications for existing rights of preemption prior to 2003. I thought from that Act that you weren't able to create new rights of preemption after the 2003 Act, but I wondered maybe if you could maybe give me chapter and verse on that. It's sections 83 and 84 of the Title Conditions Scotland Act. I thought meant it wasn't possible to create a new right of preemption, but I don't know. It sounds like that's not right because you're saying that's standard council practice, but it might be useful just to kind of give me chapter and verse. If you're not able to do it now, obviously, it'd be useful for the report, because I wouldn't want to have a report that contains something that's now no longer open. But I don't know if you know the answer to that at this point, and I'll bring Chris in as well in a second. But maybe Alan first of all.
I'm afraid chapter and verse is not something I'll be able to to comply with at all. My understanding is, and having not looked at that Act for some time, I wouldn't be able to answer that specifically. I would say that this will exist as a contract in a contractual position between the parties. So that will exist as a contractual. So whether it can be built into the title, my understanding was that it could be. If I'm wrong on that, I will check that. But
sure.
In respect of it's not in respect of preemption. I am aware that local authorities have greater rights in setting burdens than other bodies. Whether that extends to preemptive right, I couldn't say at the moment, and that's something I'm happy to check if that's something you'd like me to do.
Well, yeah, no, please do. I'll come to Chris in a second on this. I mean, one of the reasons I was asking is that I did notice, and I did wonder whether the intention was to create a contractual right, because one of the changes on the conditions moves from a right to preemption turning into an option to purchase at market value as a preemptive right. And I'm going to pose this question of Chris. I don't know who drafted the changes, but I was just interested as to whether there was an intended difference between a right to preemption and an option to purchase at market value as a preemptive right. But maybe the point in principle is better for Chris to deal with first of all, then you can maybe address that more specific question.
Sure. I think in terms of the point in principle, the idea is that if it comes down to it, we have the built-in preemptive right or contractual right that's in there for the council to purchase at market value, which differs from the sale price value in the other circumstances. And I suppose that was included, as Alan mentioned, as it seems to be fairly standard throughout the authority to there. In terms of the property law aspect of it, I am not a property lawyer by any imagination. My potted understanding is that local authorities can still have preemptive rights, although I'm more than happy for Alan to check that. But in terms of whether that falls under a preemptive or a contractual right, I think we'd be happy for the actual side to accommodate for the two differences between the sale back and the pension.
That's very helpful. Certainly, if there is an exception allowing local authorities to have rights of preemption, it would be good to know that. All right. I mean, there is a slight potential pinpoint for ministers, I guess, as to whether they would be comfortable giving questions to right of something that legislatively has been outlawed, but that's for ministers to decide rather than anybody, well, I guess. But that may be an issue. I mean, it'd be useful if certainly whether this requires to be dealt with through resolutions, or whether you can find out today, or whether you'll be able to just submit a kind of a further note on this within the next couple of days, Alan and Chris. Just to give chapter and verse to make clear to the register that they need not worry about that, then that's absolutely fine. I'm very happy that you do so. My other question, which hopefully is a simpler one, is on condition Condition 6 as amended, and let's say that there is no ability to find another community control body, and let's say the council don't exercise their right of preemption over this. The market value sale, is it anticipated that the sale or the market value will be by the actual marketing of the property? In other words, presumptions about willing buyer and willing seller, following on a kind of a reasonable and professional effort to sell the property, and then the council would then take a view as to whether to exercise their right of preemption, or would it be anticipated that effectively you'd get a kind of, without going to sale, you'd effectively get kind of a market value that would be the price offered to the council, say by the district valuer or some such person, and then that would be the way it would proceed before the appellants would then be free to dispose of the property. But again, it may not matter an awful lot, but again, I welcome views as to how you would anticipate market value being tested in this context. I'm not sure who wants to go first on that one either.
Sorry, Chris can go first.
No, the choice.
In fact, it would be appreciated.
Everyone just sort of stands there slack-jawed. Yeah, I think without deferring to Sarah immediately, our understanding is that a valuation appropriately qualified independent valuer who could come and assess the policy. I'll defer to Sarah if she has any additional thoughts.
Certainly, that would be my understanding, that the building would be valued. Obviously, there's not a lot of buildings that would make it easy to work out a market value, so it would need.
Yeah, that's right, and I think that's kind of my point in a sense. Context of is and market. It might even feel slightly unfair to go through a marketing process as if I kind of somewhere elsewhere might have a chance of buying, only to find out the council then, happening and steps in. And it might be equally unfair if it was a fellow local resident from the council as being somebody from off the island doing so. Either might be unfair, but that's very useful. Usually how you would anticipate that that valuation exercise being undertaken. Okay, that's helpful from that point of view. Moving on, and I think I indicated before it might be sensible to deal with conditions 7 and 8 together. And this is the issue about the renovation work, and this is obviously, as Chris says, had the hands of lawyers all over it, and is a bit longer than it was before. Oh, I think we may have lost Sarah on the call. Hopefully she can rejoin us if we have lost her. I think she dropped off the call just now, but I'll maybe ask this question of the lawyers just now, and see what the situation is. And again, when I do see the merit and the benefit of kind of a more full explanation as to how these clauses would work to protect the interests of the council in these respects. Again, from the appellant's point of view, the amended wording does suggest to me that the previously indicated grounds of appeal. Oh, Sarah's rejoining us. Hi, Sarah.
Sorry.
Dropped out. I've been waffling for the last couple of minutes to give you time to come back in again. I've not even got to asking Chris a question yet, so I'm now going to ask the question. I assume that on the basis of the agreement of terms that you're content with the wording as now proposed. But again, if either of you want to, starting with Chris this time, either you want to just explain a little bit about some of the background and some of the protections that are in there, that might be useful effectively for my understanding and for the record.
Sure. Yeah. You're correct in your assumption. The background to this is really that the appellant wanted to have it laid out the work that in terms of avoiding potentially if the authority has a change of staff members or something that might anticipate viewed as reasonable was sort of a flavour that went throughout all of the conditions. So the appellant was really looking very specifically on how things should be done. So that goes part of the way to explain the length of the new clauses. We also process went to a local architect, a local context, the appropriate timescales for these renovative works to be carried out, who will be the 2 years. However, most of the feedback suggested that it should be around and giving some comfort to the authority that the works were ongoing, that it wasn't a case of sitting on the appellant's hands and not actually doing anything. Those updates were sort of built up 3 years, which then could extend to the 5 years with specific reasons for that. Or that sort of led to in terms of negotiation, and the appellant's happy with the reasons being set out in those.
Thank you. And that causes.
No, I think what Chris said was fair.
Yeah.
I would just add that during the appeals panel, that the works were undertaken as quickly as possible, because it's quite and I think the position of the appeals panel was it would benefit from Castlebay would benefit from the redevelopment of the building. So it was just, they were keen that it would happen, as quickly as possible. And throughout, I understand why Barra were maybe unhappy that it wasn't prescribed sufficiently, but throughout there's always, I think in the conditions, the appeals panel were keen to build in discretion whereby these things have now been prescribed. Had Barra come back before the 2 years and said, we can't get a builder, and that had been set out, etc., I think the appeals panel would have felt that would have been, an extension would have been granted. But I understand that Barra wanted to have that position set out in prescriptive fashion. And I think that's what we've certainly tried to do. And I thought Sarah had disappeared when you started reading that clause. I thought that was the reason why she'd left. But that's I mean, that's what happens when you get a couple of lawyers working on something. But I think hopefully it works, and ultimately it works.
I mean, I can completely see that the reason why it's ended up as complicated is because it is dealing with the imponderables of the future. Where I saw that clause, I'm just skimming through to make sure that I ask any residual questions. My questions were about the sort of time periods and long stop dates, and the difference between reasonable aspirations and the long stop date by which it might be reasonable for the council to lose patience or whatever. But the long stop date shouldn't become a target date and all that kind of stuff. Or what if, as it transpires, it turns out that a more modest set of renovations is reasonable and perfectly sensible? How then do you accommodate that? By giving full protection to the council without being unfair on the applicants and the appellants in this case. So I can see, I can entirely understand why nuancing, anticipating of every conceivable outcome lengthens the clauses, and I certainly didn't see any particular issues that I hadn't identified. I mean, there is a lot of uncertainty and there's a lot of vagueness because a lot of things can happen. And some of the what's been explained by the appellants as to might happen, even with best endeavours. It's an unpredictable world, and obviously there's sort of potential funding issues around all of that. I see also a clause built in similarly if certain things happen of another community body taking the building over if needs be. I mean, I had wondered initially, although I'm not seeking views on this, I had wondered whether there were alternatives rather than reconveyance to the council, which sounds a bit like a nuclear option in the circumstances. But I can see why it's in there because of the various other provisions that can be designed to avoid that happening. But again, the bottom line is if the appellants are content with those clauses, there was nothing appliqué to me that kind of really jumped out at me. And especially, I mean, just going back to the question that Sarah answered earlier, of what even ignoring the renovations, what's the community benefit that's brought by the co-op? And she's given a clear answer that even forget their renovations, that there's a clear benefit that will take place over the period ahead. So even if the renovations don't end up as successful as everybody hopes they will be, the community benefit case is made. I think that's the kind of the essence of all of that from the way I'm looking at this. And I take it nobody would disagree with that as a proposition. So on that basis, I don't think I had anything else given the state of agreement that's been done for all of that on conditions 7 and 8. So I had no further questions in that respect. And that leads us on, I think, to condition 9, which was the ranking. And I wasn't intended to spend really any time on that because when I was looking at this, where I was going to ask questions were effectively in exactly the same territory that the amended condition addresses. In other words, that the third-party funding, and unless the appellants have still something more to say about the ability to get third-party funding, that a security that relates to the funding of the renovation works, I think is the right way forward. It looks to me to be the right way forward. And the other thing that was in my mind is that the council's security has a natural cap to it. In other words, the value of the property, and it's a cap you can anticipate from the outset as to what it's going to be. I mean, the property could increase in value, but within reason, you can broadly anticipate what the cap would be. The problem with the council going second in ranking is that the amount secured through renovation work from funding is quite unpredictable. And therefore, the council might have suffered an unfair prejudice if they were made to go second. So that seemed to me to be my assessment of that. But those concerns and those questions that I would have had seem to me to be met by the amended condition. I don't know if either party want to say any more than that, but that's just a kind of slightly cut to the quick on that. That looks like nods from that, which is fine. Condition 10 was never subject to appeal, but I reference it again just because of what Alan mentioned a few minutes ago about the fact that the title condition will include certain burdens that will protect the council's position. But that is unchanged from previously and was not a ground of appeal, which is fine. So that I think goes through the conditions. As I say, I don't think we specifically need to address the question that I posed as item 13, that is to why all the conditions are needed in order to protect the interests. I'd like to ask one question about windfall, but I'm also reminded that Alan wanted to talk a little bit about one of the other decisions by the council in a separate community asset transfer case that he's not had the chance to reference now. Do you want to say something, Alan, now about that?
Yes, very quickly, and I'm happy for yourself to discard this, or for Chris to say that it shouldn't be admissible because I haven't given any notice of it, and it's really through omission from my part more than anything else. So I think Chris in his appeal referred to other community asset transfer requests, and I had a look at them this morning. The only one I had access to the disposition of was in relation to North Hewest Community Council, and that was for Lochmaddy Primary School. So I looked at this disposition for that transaction just not long before this hearing, and the burdens are actually different from what's set out in the letter that Chris had access to, and probably what anyone in the public would have had access to in the website. So I think the conditions that had been set in that letter were fairly minimal, but in the actual burdens in the conveyance, they were very similar to what had been set here initially, such as the clawback being 10-year period, that sort of thing. So I mean, if it was just for comfort more than anything else, to say that it's that the conditions as they were initially and really how they've turned out after negotiation weren't always absolutely different from every other transaction that Corliss had. So I'm just glancing over it just now. The economic development burden, there's a clawback. It's in similar terms, maybe even a bit more complicated, but you're talking the clawback period is 10 years. And it's, although notable, it's in this instance, it's 50% of net sale proceeds. So it was just that it was different, and there's an economic development burden in terms of reversion. If there's no significant development within 2 years, the purchaser, if requested by the seller, shall reconvey the property to the seller, for which reconveyance the seller shall repay the price to the purchaser. So it was just a point I noticed this morning. Happy for you to disregard as you see fit. But just given that we're in a forum, Buva and I are in this forum, I thought I'd let them know that that is the case. And I haven't had access to the other ones, but this is certainly one of the three. So there seems to be a disparity between the letter that Buvare had access to and what actually turned out to be the case. So I just thought I wanted to make that point, and I will leave it with the chair and just decide what to do with that.
Yeah, I mean, I don't, Chris, you've heard that, and Sarah as well. I don't know if there's anything you want to say that's relevant for me and my report on this.
I suppose the only thing is, I think we were focusing in on the general wording of these letters, and I think it's specifically to the North Uist one, it was in terms of should there be no significant development or betterment, and I think Alan may have repeated that again in the actual disposition. That wasn't present in the conditions that we were initially set, and I think it was just to focus in on that. Because the conditions we were set were based on completion as opposed to a significant betterment or development. It was just to raise that, but that's all been amended in the agreed conditions, so I think we're fine with that.
Yes, from the way the amended conditions proceeded, but it's very useful and very helpful just to put on the record from the council point of view, just what that position is in relation to the different. The different parts of that. So that was all the conditions there. I don't want to necessarily spend some time going through the report that I wrote in relation to Brecon Infirmary that's on the agenda. I think most of the references there. Oh, I think we lost Alan. He's disappeared off screen just now.
Apologies, I just turned my camera off. Sorry.
Oh, right, okay, no, I can see your initials at the bottom, so you're still there, no problem at all. So I don't intend to really go through the clawback or standard security conditions, because that I think's been covered already. The only thing that I was just going to ask, I think it's probably for Alan mainly, is on the question that troubled me a little bit when I was looking at Brecon. And if you look at the paragraph numbers that I've referenced you there, it's still the kind of the possibility of a windfall to the appellants. And the windfall here might be the situation where if 10 years are up and the standard security is no longer applicable, the right of preemption has not been exercised, but the property is then sold for a profit. Now, the Constitution requires any money or any assets to be churned back into community use that's similar to that which is set out at present. But in contrast to the situation in Brecon, there's no external controls over the appellant changing its constitution and deciding it doesn't want to use things for community benefit anymore, and then making a profit from the organisation. Now, again, I'm not for a moment suggesting that's what they would do. I really want to emphasise that. Can't emphasise that enough. But in terms of protection of the council asset, and again, I asked Alan the question: is that a possibility? Incredibly slim and unlikely. though it may be. And are you satisfied that even in that longest of long terms, that's a sufficiently small risk, effectively, not to worry about? In the briefing example, the difference, to save anybody who's not read my lengthy report on that, the difference is that in Brecon, the Community Asset Transfer Body was a charity, and therefore was regulated by Oscar. If it were to do something that was a change of its terms. As I read the Constitution, the appellants are capable of being a charity, but are not a charity at present. So again, if that's wrong, you can tell me if that's factually right or what. But maybe just mainly from the council's point of view, given that sort of slim risk, low level of risk, are you still nevertheless satisfied that the conditions imposed strike an acceptable balance? Because everything is a balance. There's no council of perfection in all of this. Is that, in the council's view, an acceptable balance in seeking to further the principles of community empowerment?
Yes, absolutely. I think the appeals panel had no appetite to extend sort of the council involvement to any period after 10 years. Didn't feel that was reasonable. Other than, of course, there's a condition there, if I can find it, in terms of route use restriction, and so that will, to the extent that's enforceable, that exists, and that will, it certainly is hoped and anticipated that would remain. So that is condition number 4. The property should be used solely for community use by the purchaser. So the purchaser, the definition of purchaser, certainly should include the successor. So with that in mind, and even without that, I think the appeals panel felt that after a certain period, and as you said very well, that there would be sufficient community benefit after 10 years. But after that period, it wouldn't be appropriate to try and constrain the building further, particularly on reliance of condition 4 there. So I think, as you say, on balance, I think the appeals panel were happy that there was sufficient protection there.
Okay, thank you. And Chris, do you have anything on that point?
No, I don't think I've got anything to add above what Alan has said there. I would have flagged up condition 4, and again, the other routes to sale that are built in terms of disposing to a community controlled body as being a requirement, as hopefully helping the council there.
Okay. Thank you for that. I was conscious that I said at the start of this that we'd take a break at 11:30 if we needed to. I, for my part, have gone through the outstanding questions now that remain. I've actually just thought of one more about the right of preemption, just while it's in my head. I take it the intention is that that's only to be exercised once. In other words, although it may be a contractual right of preemption and not one in classical conveyancing terms, nevertheless, the analogy that you've got 21 days to exercise it and you only exercise it once would be the way it would apply, even if it's just contractual. I presume something of that nature would apply, and I see Alan nodding to that. I didn't have any other further questions arising from the matters from this morning, and I think we've gone through all the items that were set for the agenda. I'll come to next steps in a moment. And next steps regarding conditions, of course, is now no longer necessary, the agreement between parties. Is there anything else that anybody wants to say to me at this stage on the matters arising this morning? Then we'll talk about next steps. Sarah?
Yeah, when we started this process, we obviously did a search in land registry, and we were working on a plan of the building and the area surrounding. Alan has said today that they've now produced a plan and registered the land, but we haven't seen any copy of that. And I think it would be remiss of the council if they didn't show us what has been registered.
Okay. If Alan wants to respond to that or say anything more.
Yes. Absolutely happy to share the plan that was used. And it was just based, I think, from memory, the title was transferred to the Corla in possibly 2010. So just based on the plan that was with, so it was transferred from the co-op to the Corla in 2010. There was a plan, I think, or that disposition certainly referred to a plan. Whether that plan was attached to that disposition, certainly maybe referred to an earlier plan. So it is just that area. And the plan has been brought up to the standards required by register. So absolutely happy to share that, and I'll send that on. It will be, as I suppose, it will also be available at Register Scotland, but I'll send that on to you, no problem.
Okay, thank you. Right, in terms of next steps, I mean, the main one, I guess, is just a bit of further information in relation to the right of preemption. There's also potentially an issue in the event that my understanding of the 9th of March letter is different from the 17th, but I think we don't anticipate that arising. What do parties think we should do now? This links to the question of whether you want to take 7 days to make a closing submission, or whether instead of a closing submission you want to make legal submissions on the preemption point that will have to be addressed. I'm relaxed as to whether those are combined together, or you want to do it separately, and how long you might think you need. If you think, I know it's probably an unfair question, because you need to think about what the problem is and whether there's a problem. If there's a very straightforward answer, you can tell me in 24 hours, but you don't know if it's a straightforward answer or not on the preemption point. So I don't know what you want to do. Would 7 days be enough to come back on the preemption combined as parties think fit with a closing submission, or what would you prefer? I guess start with Alan first of all.
Thank you. Given that it's something that I ought to know, given it's something it's important that the council knows, I will certainly endeavour to look at that between today and tomorrow, and I'm happy to pass that to Chris first if he thinks that's helpful. But I'll certainly take the initiative and either send it to DPA or send Chris whatever you prefer me to do. Okay,
that okay, Chris?
Yeah, I think that's sensible to avoid doing an overlap of looking into
that's fine. Yeah. I mean, I have target dates for completing my report, although it's not for a little while yet. Though clearly, having had the hearing and mindful of the agreement between the parties as to the conditions that are there, I don't want to be holding anything up any longer than is necessary. So I'm keen to submit my report as soon as I can. So if what you could do is just provide further information just as soon as you can, but if it does end up taking longer than you expect, just keep us informed, both to Emma and to Jane, as I mentioned at the top of the call here just now. And if you need more time, that's absolutely fine. If there's a simple explanation, for example, a local authority exemption, then that's equally fine as well. And I can just reflect that in the report. So I'm open-minded. And I'm open to representations that I'll reflect in the report. But subject to that, my intention is to complete the report just as soon as I can and get that submitted for consideration by the Community Asset Transfer team in Victoria Quay, who will do a note for the Minister and take that forward from there. So that all sounds fine from my point of view. Unless there was anything else any party has, and I look around the screen, no one is immediately indicating that. I will thank you all for your participation and your very clear submissions and responses to my various questions. And again, grateful for the seeing the conditions in advance of the call today. And I'll leave you with more of your day than perhaps you originally thought you were going to have, and draw the hearing to a close. So thank you again.
Thank you very much.
Thank you.
Thank you.
Thanks very much.